Limits to where Illinoisans can sue the state over allegations that laws are unconstitutional is equated to the tyranny of King George III. Good morning, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. Love to get your thoughts at 217-629-7970. That's the phone number where you can chime in live and local about this issue. And we talked about this earlier this week after the Illinois Senate approved a measure that House Bill 3062. It essentially says that if a citizen of the state of Illinois wants to sue the states over a law that the citizens believes violates their constitutional rights, then they have to file it in either Cook or in Sangamon counties. And heard a lot and saw lots of people online reacting to this story. I'd love to hear from you. Again, 217-629-7970. That's the phone number here with Springfield's Morning News. And we'll get to some of the debate here. But, of course, get your phone calls lined up at 217-629-7970. This is going to be a debate on the House floor between several individuals, including State Representative Jay Hoffman, who is sponsoring this bill, as well as the Republicans who were reacting to this. You have State Representative Patrick Windhorst, State Representative Dan Calkins, who has a pending lawsuit in front of the Illinois Supreme Court concerning the gun ban challenge, and even State Representative Dan Ugasti talking about the importance of allowing for people to sue the state if they believe that their constitutional rights have been diminished. So get your phone calls lined up, and we'll hear from the debate here in a moment. But let's get right on into the debate back and forth about this measure that ultimately Republicans say is a breath of tyranny in the state of Illinois. So let's get right on into it, starting with Jay Hoffman explaining the bill and what they want to see ultimately move forward, which did pass the state legislature, both chambers, and now can be sent to Governor J.B. Pritzker. Here's that debate.
This is an initiative of the Attorney General of the state of Illinois and would indicate that Sangamon and Cook counties are the only venues proper for Illinois constitutional claims. You know, over the past 3 years, the Attorney General's office has been forced to respond to, I would call them in many cases, frivolous lawsuits that have strained the office's limited resources.
This is the same Attorney General's office that has requested from this body additional authority to investigate and bring actions against crisis pregnancy centers this session, to bring actions against and investigate gun manufacturers this session. It doesn't seem that the Attorney General's office is lacking in resources when they're constantly coming to this body requesting more authority to do things. So I think that argument strains credulity.
What was that word?
I'm not sure.
Credulity? What did you say? Okay. Interesting.
I'm trying to test the typist upstairs.
Yes.
We have seen many counties throughout our state pass resolutions saying, we don't feel a part of the state of Illinois. We don't want to be a part of the state of Illinois because they're passing these resolutions because they don't feel the respect from certain parts of the state of Illinois. And what this bill does is it basically says, you're right. You can't go to court in your local jurisdiction. You can't get justice in your local jurisdiction. You've got to come to Springfield or Chicago to get justice. And that is fundamentally wrong.
The Democrat sponsors of this bill are acting just like King George III. In the Declaration of Independence, the Americans declared that King George was unfit to rule because he was forcing them to be tried overseas by his tame courts for made-up crimes. The Democrats today are doing the very same thing. They pass unconstitutional laws to make law-abiding citizens criminals, and then they make those same citizens travel hundreds of miles to a kangaroo court that they control.
We are now about to affect an individual's right in this state to challenge the constitutionality of laws and executive orders to solely 2 counties. We are denying access to courts. And as the sponsor already pointed out, if it's a problem for the Attorney General's office, there's a remedy that exists. The Supreme Court of Illinois will consolidate the cases. A petition can be filed, and the cases can be consolidated already in a venue of the Supreme Court's choosing.
There have been judicial shopping by filing TROs without early notice to the Attorney General's office, whether they were COVID-related restrictions, whether they're masks, whether they're vaccines, whether they're safety acts, whether they're assault weapons ban, and the list goes on, to the extent that one lawyer was charging people $200 just to have their name added as plaintiffs to the lawsuit. Now, where have these cases ended up? They've ended up in Sangamon County. They've ended up here.
So let's get your calls at 217-629-7970. Again, the bill ultimately passed the House after passing the Senate late last week, and it's queued up now to be sent to Governor J.B. Pritzker, despite Republicans saying that it's reminiscent of the tyranny of King George III. Your thoughts on this at 217-629-7970. Good morning.
Morning.
Good morning.
Hey, yeah, I kind of agree with that, with the last speaker there on the House floor. I guess it was the House floor. But this is just a way for the Democrats to pour a bunch of money into the Sangamon County jurisdiction judicial races, put their own judges in, and then they've got everything, judicial, legislative, and executive, and it's just a way for them to consolidate control.
Yeah, and the sponsor, Democrat from Swansea, Jay Hoffman, he said, hey, listen, Sangamon County's Republicans right now. And, Cook County, sure, they're Democrat judges up there, but Sangamon County's all Republicans. So you're saying that this is ultimately going to set the groundwork for Democrats to fund Democrat opposition to those Republican judges here in Sangamon County.
That's exactly what the governor and the legislative leaders did with the Supreme Court. They'll just do it in Sangamon County for a lot less money.
Yeah, and some of the Republicans also, I appreciate the call, they highlighted how Democrats drew the new judicial maps to favor Democrats, especially when it comes to the Supreme Court map. So interesting perspective there, 217-629-7970. Good morning, you're on WMAY.
Yes, hello, Greg.
Hey.
Ismail, Sean Gotti here.
Right on.
Look, this is all about control. This is about where they're going to take these cases where they have the most control, the most opportunity to get what they want. It's not about what the people want. It's about what they want, and this is the way it's going to be. They don't care. They have no inkling of ever siding with the people. They're only siding with themselves.
Well, and some saying that this law, if it does get signed by the governor, which is fully expected, it's a Democrat initiative and something that the Illinois Attorney General Kwame Raoul has pushed for, it's going to face legal challenges. Might go to the federal courts to challenge this particular measure that limits where people can file lawsuits against state laws they say are unconstitutional. And it was even brought up that sometimes there are indigent people who don't have the funds to be able to even pay for the filing fees, let alone travel hundreds of miles to get up to either Springfield or Cook County. One lawmaker, I believe it was Dan Ugasti, it was Patrick Windhorst, who said that from where he lives to Chicago, it's the same distance from where he lives to Atlanta, Georgia. So he says ultimately that's just way too much of a burden on an individual who wants to have a remedy for them feeling like their rights have been taken away by state statute. But again, the Democrats want to limit exactly where you can file those lawsuits to just Springfield or Cook County. Good morning. You're on WMAY.
Hey, Greg.
Hey.
Hear me if I'm wrong, but I think, if I recall, the state Supreme Court has been in Democratic hands for the past 35 years.
Don't know the exact history, but, I mean, it's in Democrat hands right now.
Yes, it's been in Democratic hands for a very long time. But that's supposed to be moot. But I can agree where they should be able to go to their local courts initially. If the local court doesn't want to hear it, then it could go and say, then there's an appeals process, and the appeals process ends up in Springfield or Cook County. But still, the initial should be going to the local circuit courts.
Well, and we'll see if this measure withstands any kind of federal legal challenges that could be brought, because, again, it limits exactly where people can file lawsuits challenging state laws. And I think it was interesting, too, that part of the rationale for passing this was, listen, the Attorney General of Illinois has got all these cases all over the state they have to deal with. You remember the mask mandate challenges that there were and the vaccine mandate challenges that there were sprinkled all across the state. They were consolidated in one particular county and got some rulings in favor for the plaintiffs and not favorable for the state. Then you had the Safety Act challenge that was in Kankakee courts, and they got a temporary restraining order there. Then you had the gun ban challenge out of Macon County and Effingham County and White County, where there were temporary restraining orders there. Those weren't Sangamon or Cook counties, and obviously that was another impetus for the Democrats to advance this bill. But back to the limited resources. I think Patrick Windhorst, he highlighted this, how if there's limited resources for the Attorney General to take on these cases, then why did the legislature advance legislation to let the Attorney General start suing the gun industry or to go after pregnancy resource centers that don't offer abortions? Wouldn't that strain the Attorney General's resources as well? Let's get another call in, 217-629-7970. Good morning.
Hey, yeah, Greg. I guess the moral of the story really is don't pass stupid laws and you don't have to go to stupid places to defend yourself.
And I take it you're talking about like the Safety Act, no cash bail, or the ban on certain semi-automatic weapons.
Yeah, the mask mandates, the semi-automatic weapons, any of those laws are, you pass ridiculous laws that are infringing on the rights of the people, and then you further infringe their rights by telling them where they have to go to file their lawsuits. This is just ridiculous.
Again, Dan Calkins, somebody who sued the state over the gun ban, he equated what Democrats are doing to the tyranny of King George III. And it's just another day at the State House. Let's just put it that way.